Ladies and gentlemen, both those present in this room and those joining us on YouTube, welcome to the launch of Perspectives on Caribbean Law, a compendium of legal essays edited by Professor Shazida Ali and Professor Stephen Vassiani. I am Alicia Stone, and I'd like to specially invite some others. Professor Marcia Roy, Director of Graduate Studies and Research here at the University of the West Indies Mona campus. The Honorable Madam Justice Hilary Phillips, about whom we'll hear some more later on. Other honorary members of the judiciary. I'm advised that there may also be representatives from our three law schools, from Norman Manley Law School, from Hugh Wooding Law School, and Eugene Dupuche Law School. Welcome. Now, I must acknowledge the contributions of those who've worked really hard to produce this text, without whose sacrifice and diligence we would not have the benefit of this unique compendium. And so, at this point, I'll acknowledge the work of, with us in this room, well, I'm not seeing Dr. Derek McCoy, but he may be here soon, but certainly Dr. Derek McCoy, Professor Shazida Ali, Dr. Celia Brown Blake, Dr. Colleen Lewis. And joining us on Zoom, we have the Honorable Mr. Justice Andrew Burgess, Professor Stephen Vassiani, Dr. Jason Haynes, Andre Shackelford, Gabriel Elliott Williams. Miss Dorcas White is well, but she regrets that she's unable to attend today. I'll also acknowledge the contributions of Professor Gilbert Codellini, Dr. Nita Waite, and of course our beloved Suzanne Folks Colson. So, we're underway. I have welcomed, I have acknowledged, and so now I will invite. I'd like to invite Professor Marcia Roy, again Director of Graduate Studies and Research here at UWI Mona, to deliver greetings.
Thank you very much, Alicia. Very precise, typical lawyer. Ladies and gentlemen, when one of your girl deans at Mona invited to come and speak, you just show up. And I would like to remind you that the deans of the Faculty of Law, of Medicine, of Social Sciences, and of Humanities and Education are all women. In fact, Dr. Heather Ricketts is the dean of the largest faculty in the UWI system. So Shaz asked me to come. I don't really know why. So greetings, everybody. But when I was looking at at the flyer that I got, and I was thinking about Suzanne and thinking that, yeah, she's silent, but she speaks. And I was thinking about Tracy Robinson, and sometimes as the director, or even before I was associate dean in the Faculty of Science and Technology, I have a tendency to go overboard. So sometimes I'm too harsh when I have to make a decision, and sometimes I'm not harsh enough. And Tracy is always the one who kind of keep me balanced. I hear her voice in my head all the time, natural justice, and I try to be balanced. And when I'm not sure, I call up Tracy and say, okay, what this mean? Because I get a decision from the Senate, which is the highest decision body, and they don't agree with me, so I have to do it again. So Tracy, what this mean? And Tracy tell me, but I still don't accept it. Then I call Celia, and Celia tell me the same thing that Tracy told me. Then I call the PVC for Graduate Studies and Research, Rosemary Antoine, who is now the principal of the St. Augustine campus, and she told me the same thing that Tracy and Celia tell me. And I called my friend George. George, he knows how I think, and he explained to me in my kind of language, and maybe then I will accept it. So, ladies, thank you very much for keeping me balanced. And we celebrate Rose. You know, Rose Cameron is our first PhD of law. Congratulations. I haven't met Stephen yet. I was hoping that Stephen would be here, Shaz, so you need to arrange a meeting with Stephen. But our principal, Denzel Williams, he keeps telling us that our responsibility is not just teaching and learning and research, but our responsibility is also advocacy. And this is what the Faculty of Law is very good at doing, because you know most of us really don't understand the law and we're very confused about it. So of course when you write it down or you have all of these forums that you have, it's very important to educate our people about the law. And who else will talk about Caribbean perspective except us who live it every day. Thank you very much.
Thank you very much, Professor Roy. Now, colleagues, I must admit a grave error on my part, and I'm going to try to make amends. I will now acknowledge the contribution of Dr. Rose Cameron. Dr. Rose, please forgive me. So the editors have worked, and I'm sure tirelessly, to produce this work that we now benefit from, or we will benefit from. Work about Caribbean law. Work that I imagine not only just describes what this Caribbean law is, but work that pushes us to imagine what it can be, what it ought to be. And we're indeed grateful. I am. And so I think it's fitting that we hear from the editors themselves what it is that they would like to say in this moment. And so on that note, I'd like to invite Professor Shazida Ali to deliver some reflections from our editors.
Thank you, Alicia. Honorable Madam Justice Phillips, Professor Roy, all the other distinguished guests here present, including former Chief Justice Delia McCalla. I wish to acknowledge all the distinguished members of the law faculty who are here in the room as well as on Zoom. We have our distinguished contributors. I also want to welcome our friends who are joining us online and on YouTube, and those of you who have come here to be with us today. So good afternoon, everyone. And it gives me very great pleasure to present the reflections of the editors on behalf of my co-editor, Professor Stephen Bassiani, and myself. So let me tell you a little story about how this book came about. In mid-2021, in the midst of COVID, when we were also considering different ways to mark the 50th anniversary of the Faculty of Law at the UWI, Professor Bassiani suggested to me that we try to put together a book which would include submissions by both current and former colleagues in the law faculty, particularly those who were connected at some point in time with the faculty at the Mona campus. So we then reached out to all current lecturers, as well as other colleagues, who, at some point in the faculty's evolution, had some sort of association with the law faculty here on the Mona campus. The response from our colleagues was encouraging, with many agreeing to participate in the project, but a few had to decline due to other publication commitments. So as you will see on your program, these contributors, and you've heard them mentioned already, but I must acknowledge them again, are the Honorable Justice Andrew Burgess, Dr. Celia Blake, Dr. Colleen Lewis, Dr. Jason Haynes, Dr. Neto Waite, Dr. Rose Cameron, Gabrielle Elliott Williams, Andre Shackelford, and of course, our beloved late colleague, Suzanne Folks Golson. So these colleagues were all invited to submit a chapter on any academic area of their choice. And so that is why you will see in the book that all the chapters reflect a broad range of scholarly interest and expertise of these contributors. And so collectively, they provide a panoramic perspective of the law in the Caribbean. But apart from these academic chapters, and given her involvement with the faculty since its inception, Dorcas White was specifically asked to provide reflections on 50 years of teaching law. And so that represents her contribution to the publication. Now, having secured the undertaking by colleagues to participate in this project, the mammoth task of compiling this work began. And so, the next year and a half saw a barrage of emails, text messages, and phone calls between me and the contributors, where I unashamedly pestered and even badgered them to submit their chapters or to make any recommended changes in a timely manner. And so in retrospect, it's a miracle that they never blocked me as a contact. And so I really want to thank all the contributors, not only for putting up with me, but also for their commitment to seeing the project through to its completion, as we invariably encountered various delays along the way. And so you can see, we started in mid-2021. The book was published at the end of 2024, so over 3 years. But apart from honoring the legacy of the law faculty at the University of the West Indies, there was a broader twofold vision for this book. The first objective was to provide a forum for our colleagues to publish their work in a collection that would be accessible and hence provide further visibility for their work. But that also feeds into the second objective, which is that as a faculty, it is important that we not only promote relevant legal scholarship, but further, that our work makes a valuable contribution to the development of our own Caribbean jurisprudence. Too often, our attorneys and judges resort to using resources from other jurisdictions, particularly the UK, since the work of our local and regional scholars is not always readily available. I recall that when I was a law student, and I'm sure my colleagues here would agree, that the majority of the textbooks and articles we studied were written by English academics. In fact, a few weeks ago, we had a visit from some members of the first graduating class of 1973, and they said that practically all their resources were foreign and from UK scholars. But today, I am proud to say that a significant number of the resources on the worksheets for our law students are homegrown, written by our local and regional scholars. So, ladies and gentlemen, I am sure you'll all agree that it is important for us to tell our own story. In an era where there are plans afoot for Jamaica to become a republic and to replace the Judicial Committee of the Privy Council with the CCJ as our apex court, it is becoming increasingly important for the laws of the Caribbean to be analyzed and even criticized by our own scholars, and that those findings are made available to everyone involved in the administration of justice. In many respects, the Caribbean is a unique region. And so the unique features of our legal system need to be recognized, and we need to recognize this as our own identity. So, this publication represents one example of Mona Law helping Caribbean jurists to write our own story by our own people and for our own region. The production of this compendium would not have been possible without the input and efforts of a number of persons. So apart from the contributors, we would also like to extend our gratitude to the external reviewers who took the time out of their busy schedules to provide critical feedback for the authors on how to refine and improve their chapters. We would also like to thank the Mona Law research assistants who were involved in the production of this book. First, Dr. Rohan Clark helped to provide some support in the early stages of the publication, whilst latterly, Dr. Yentel Williams was instrumental in bringing it all together by her role in proofreading and indexing the manuscript. We'd also like to thank Dr. Derek McCoy, Attorney General, for writing the foreword to the publication. And of course, I must thank our publisher, the University of the West Indies Press, for trusting us with submitting a volume that is worthy of publication under their imprint. Finally, although I haven't yet heard her presentation, but in anxious anticipation, I would like to, perhaps prematurely, thank the Honorable Justice Hilary Phillips for agreeing to deliver the book review today. I understand that as part of the process, she had to read the book twice. So I think she deserves some applause. But indulge me for a moment to just take off my editor's hat and put on my dean's hat to thank all of you for coming here and joining us online today. Your presence is testimony to your confidence in Mona Law, and we truly appreciate your continued support as we continue to build Mona Law as a faculty that produces legal professionals and legal scholars who will continue to play an instrumental and transformative role in the development of the Caribbean. So thank you, and do enjoy the evening.
Thank you very much, Professor Ali. Now, I promise this will not be a feature of my guiding you through this afternoon's proceedings, but I have one more admission, one more grave oversight. And so I'd like to specially welcome and acknowledge the former Chief Justice, Honorable Madam Justice Selah McCullough. Please forgive me. I hope I don't have to say this again for the evening. All right, so I want to share with you something that bowled me over as I attempted to read this text. It knocked me down, made me pause, and I think in cricket terms is bowl out or lick for six, I'm not sure, something like that. But the point is, I was... What was that? Oh, it's two different things. I was knocked out. That's the point. So I would like you to, so on the screen we should see a graphic. Because in the very first essay of this text, the very first word of the title of the very first essay, well, no, not the first word, the second word. Where's my, do we have it? Okay, thank you very much. I was stopped dead in my tracks. That's right? Dead in my tracks. There we go. There we go. Please indicate how many of you have ever seen this word before? Just seen. Ever seen the word? Other than those who've read the book. So I see nods, but not many. Okay. We're going up a little bit. How many know to pronounce the word? I see no nod. So you've seen. Okay, so this, I don't know what this one will look like now. Who knows what this word means? It doesn't seem like a lot of us. So you will probably be stopped dead in your tracks as well, as it happened to me. But here's what. Professor Ali introduces this concept to us. And she talks about the eudaimonic attorney. I don't know if I pronounce it right, but that is my concoction here. In my effort to figure out what this thing is, all I could come up with, EU means good. That's all I got. So I imagine maybe it's good attorney. But Professor Ali now walks us through what she means by the eudaimonic attorney. And she tells us that the English root for this word is eudaimonia. Eudaimonia. All right, there we go. And it comes from Aristotle's seminal piece, Nicomachean Ethics. Yeah, do not judge me for the pronunciation. I'm trying very hard. No, but really, she says that this word means welfare, happiness, flourishing, well-being. And so I wasn't so off. I found good. So yes, it has to do with good. And so I got more interested. I got more intrigued. What is this thing? Now, I had to go back now. When we first learned new words in primary school or prep school, what was the next instruction? What you had to do with the new word? Thank you very much. Use it in a sentence. So here's what I'm going to do. I'm going to borrow Professor Ali's words from page 25 of the text. This is how she uses it in the sentence. She says, inspired by the overarching idea to cultivate the eudaimonic attorney, the legal profession must consistently embrace the elements of virtue ethics and recognize the higher role it has to play in advancing and contributing to the greater good. Professor Ali not only teaches us this new word, but what this does as the very first essay in the compendium is to give us insight into the approach that may help us understand what this Caribbean law is. Eudaimonic is a word in philosophy. And so she shows us that interdisciplinary understanding of these legal concepts will help us to understand, to define and develop what this Caribbean law is. And I thought that was just amazing. So thank you, Professor Ali, for not just teaching us a new word, but for encouraging us to see the law through different lenses, see the law with its connection to different things. So no, I am not here to do the review of the essays. I will soon invite the Honorable Madam Justice Hilary Phillips to do that. Justice Phillips is a retired judge of the Court of Appeal of Jamaica. She was the president of the Jamaica Bar Association and a former chair of the Regulatory Market and Oversight Committee of the Jamaica Stock Exchange. She also served as a member of the General Legal Counsel's Disciplinary Committee. She was the acting president of the Court of Appeal in 2019. Justice Phillips is the daughter of the late Sir Roland Phillips, who was Chief Justice of Jamaica in the 1960s. She was called to the bar in 1974 and was elevated to the rank of Queen's Counsel in 1998. Throughout her long career as an attorney, she was extensively involved in civil litigation. She has demonstrated a long-standing commitment to legal education, including as an associate tutor at the Norman Manley Law School, where she taught civil procedure and practice. So the person who is here to talk really about the different essays and not just my interest and what intrigued me and what stopped me in my tracks is the Honorable Madam Justice Hilary Phillips.
Thank you very much for that introduction, and good evening all. It's such an honor and pleasure and privilege to be here on this occasion, given the purpose of the gathering. When Dean Ali asked me about a month ago if I would be willing to be the guest speaker today, giving a review of the text, Perspectives on Caribbean Law, a short book, she said, of only 300 pages. My immediate response was, this is a difficult uphill struggle, 300 pages of legal text. I nearly said, I'm so sorry, I'm not available, not at this time. Of course, if you know the gentle, persuasive Shazida Ali, that was not going to be a position that was going to survive. So in any event, I agreed. I'm so glad that I did. The book is a treasure trove of information, a great read. It has incredibly pulled together the writings of several eminent jurists on topics of which they have expertise and a genuine interest. The articles are therefore well-reasoned, cleverly written, and persuasive on the respective areas of law. So, the result at the end of those nearly 300 pages, which are digested fairly quickly, is that you're so better informed on those various subjects, so much so that you could engage in an intelligent discussion on all of them and even seem wise. Additionally, this book is for the judges, legal practitioners, law students, and members of the public. All will be able to discern the depth of knowledge of the participants and be grateful for Dean Ali and Professor Vassiani for collating the contributions of these incredible authors to share their extraordinary knowledge with us. As stated by Dean Ali and Professor Vassiani in their introduction, the 12 chapters feature articles on corporate law, the law of tort, international law, family law and ethics, focusing on matters unique to the Caribbean region. So, let us get to it then. Excuse me. I would like to get back my water. Excuse me. So, to capture your complete attention before commencing on the 12 chapters, Tutor Emerita Dorcas White shares some introductory remarks on her reflections on 50 years of teaching law. And who better to do that than the great Dorcas, who can tell you about when there was only one campus, Cave Hill, before it became Cave Hill, St. Augustine, and Mona. She says in the early stages, the students didn't even know the name of the judges in their respective regions. There were no textbooks. There was one, Caribbean Legal Systems by Edward Lang, a Belizean, and articles in English journals by the late A.R. Carnegie. So Ms. Dorcas White speaks of the faculty members coming together from their English universities, including some learned Jamaicans graduating from Oxford, and she said at Cave Hill it was a rich melting pot, and there was much energy as all grappled with the Herculean task of nursing a newborn regional institution to enable it to carry out the mandate given by our founding fathers. It's a very interesting discourse by the learned Dorcas White, and I would ask you to read it. She says, when she reaches the Caribbean Court of Justice, that many would prefer the ultimate appellate court to be in a far place where judge, litigant, lawyer, or scholar would just be a name on paper, and the opportunity to bruise eggshell egos would be diminished to vanishing point. In true Dorcas White style, she closes powerfully on this statement: "It is my firm belief that instructions exist for the glory of Jesus Christ and should function accordingly." And she wishes, of course, the university all good things for its 50th anniversary. So now we get to this first chapter, and it's well chosen, as my learned friend says, the eudaimonic attorney, the virtuous pursuit of the greater good. Dr. Ali, who is now professor of corporate and financial law, a lecturer in the LLM course in the faculty on legal aspects of corporate misconduct, and at the NMLS on ethics, rights, and obligations of the legal profession, is also an author and editor of books and various published legal articles. I have to tell you about each of these great 12 subjects. So you just have to bear with me so you understand the quality of the book that you're going to go to and buy. So, in her chapter, given that the duties and obligations of lawyers are so well captured in legislation and the canons of legal profession ethics, she wanted to focus on the less acknowledged role, which is their responsibility to society and the greater good. So the chapter focuses on the role of legal professionals in enhancing the well-being of society. That, of course, would engage my attention immediately. So she speaks about what is eudaimonia: welfare, happiness, flourishing, well-being. And she speaks about lawyers in society. She asks the question, why is it that the law could not be, this principle of eudaimonia could not apply to lawyers? And she says, it must in the affirmative. Why not? I mean, because the career is in the pursuit of excellence, furthering the aims of justice, promoting public order and the common good. So why shouldn't that goal have an intrinsically moral value and not only focus on financial success? She speaks about there are some virtuous aspects of lawyers. We do a lot of pro bono work, and many are very zealous with their clients, trustees of the public good. So why should they not have that eudynamic turn? And she speaks about, on one hand, you have the professional body that is imposed between the powerless individual and the state itself, and performing a role in the governance of society. And on the other hand, they are privileged and making a lot of money out of this profession. So why should they not undertake responsibilities to engender the belief that they're good corporate citizens? And that should apply to firms also. Firms should think about engaging their persons who work with them to do pro bono work, volunteerism, help one's community, clean up the beach, paint the sidewalk, be good corporate citizens exhibiting corporate social responsibility. Also, you need to be gatekeepers, because we know how many of our clients are nefarious, and we're able to discern that. The money laundering legislation is encouraging you to look out, not to lose the LPP, the legal professional privilege, to be a shield, but to ensure that, having discerned that is what the clients are about, reject them if necessary, but not to be a part of them. So we must be gatekeepers. So the ethical lawyer will demonstrate character through exhibiting principles of honesty, candor, confidentiality, diligence, courtesy, and fairness. That's the hallmark of a lawyer. And she, at the end of it, says, so let the lawyers make this turn to be a eudaimonic lawyer. Right? And you can start at the Faculty of Law, Norman Manley Law School. It's a very powerful piece, and it needs to be read by everybody. Then we go to Dr. Celia Blake. Now, this is a very learned lady. This is now chapter 2 of this excellent text. Caribbean Republicanism, Values and Vernaculars. Dr. Celia Brown Blake, Senior Lecturer in the Faculty of Law, Mona, and Deputy Dean for Graduate Studies and Research. She teaches trust and insolvency, but given that her doctorate is in linguistics, her special interest is language and the law. Her perspective on Caribbean law in this context, therefore, is treating with those countries in the Caribbean who had adopted changed constitutional arrangements for a republican form of government some time ago, those who have recently achieved that status, and finally those involved in current debates concerning the implementation of the same. Dr. Blake proposes that the discussion surrounds the social phenomenon of the Republican movement within the ambit of the thrust for independence in the wider Commonwealth Caribbean. It sounds goody. So in her essay in this text, she says, Caribbean republicanism is popularly conceived as acquiring the political status of a republic by jettisoning the British monarch as the head of state, coupled with the instituting in its stead our own man at the top. So she states that in the stance of the favor of becoming a republic has been informed particularly by issues of national identity, consciousness, and pride, as well as advancing the decolonization process. So then she goes into these. What are these indigenous symbols of nationhood? This is another word maybe you might have wanted to know about with the sociolinguistics and the law. That is Dr. Blake. And she speaks about people's beliefs about themselves and their identity are expressed at the level of language. And then she speaks about, well, what is the language that we have? We have taken down this English as our colonial linguistic legacy. But there are so many vernaculars. But why don't we use those vernaculars? What about the countries that have indigenous languages? What does she say? She says, we haven't even used this language as a symbol of national identity. Why? Because instead of making us proud of those vernaculars, the Creole language has been not seen as a general language. It has been distorted from the English counterparts, people say, negatively evaluated, brought shame, and incongruous with the ethos of national pride. So that is why you're prepared to focus on English as opposed to our vernaculars. In fact, this is her powerful statement. The failure to adopt, particularly via constitutional instruments, a non-colonial language as a national language that would signal a break with the colonial order was consistent with the intention on the part of Caribbean independent leaders to continue to govern in the same vein as had the British. Not like the Indian Prime Minister who said, Hindi, that's ours, we're going to protect it. No nation could become great on the basis of a foreign language. Yet she says, our Prime Minister is thinking of using Spanish, another colonial language, as another language of ours, instead of our vernacular. So that's not a good idea. And she speaks about, under this language also, the difficulty, democracy, equality, and justice. And this is focusing on the fact that our Chief Justice, our current Chief Justice, has indicated that most persons access the justice system through the parish courts. And in the parish courts, most people are speaking patois. Yet there's no identified person to translate from the English to the patois. So you have many people in the justice system who maybe don't even understand what is happening. They are maybe in the lockup and caution is taking place and they're not sure what they're saying. So she says, we mustn't be as like an unrobed attorney in open court, cannot be seen or heard. So she's exhorting the justice system to try to do something about these inequalities to access and also use the vernacular and make that necessary adjustment to adopt it. She says, the architects of the modern republicanism constitutions would do a great injustice if they proceeded with eyes wide shut to the language issue. Great piece. I learned a lot. Chapter 3 of this excellent text is entitled The Appellate Advocate and the Appellate Function in Our Court System. Now, the Honorable Mr. Justice Andrew Burgess is a former judge of the Caribbean Court of Justice, a member of the World Bank Administrative Tribunal, a former judge of the Court of Appeal of Barbados, former dean with responsibility for the LLB and LLM programs delivered at the Mona and St. Augustine campuses, served as professor of corporate and commercial law at UWI Cave Hill, was a judge of the Inter-American Development Bank's Administrative Tribunal in Washington, D.C. as its vice president and later as its president, a senior Commonwealth fellow at Oxford University. He has published books and articles on company and corporate commercial law. Now, he's a very eminent jurist. And sorry, anything he said, you just accept it, right? So that is the sort of contributors we have to this text. Now, so in the beginning of his article, Justice Burgess posits the question, what is the rationale behind creating courts with appellate jurisdiction? What is the role of the appellate attorney in the appellate process? He suggests that the appellate system, including the role of the appellate advocate, is a social agency with specific function, the appellate function, and he seeks to demonstrate how the appellate attorney can assist the Court of Appeal and the CCJ in this discharge of their functions. So he goes through, he says there's no inherent right of appeal. It's either by the Constitution or statutory authority. It consists of a hierarchical structure. You have the lower courts, the Court of Appeal, and the apex court. What's the purpose, he says, of our appellate system? He says there are two purposes: to correct error, the correcting purpose, and the universal application of law purpose, or the law-making rationale. And he says that one takes precedence over the other. He says there were two others. One of them was speaking about a function to ensure justice, another one about accountability. But those went by the way because one was too wide, and the other one was, if you have accountability and it stops at the lower court, then what happens to the high court? No accountability? No, get rid of those two. Just let's stick to the error and what he calls the universal application of law. And he says, over these 8 years, they've been discussing those two. But the correcting one, was it because there was the unskillfulness of those that were below that you're correcting? And he said, no. Happily they got rid of that and said, it's the fallibility of justice as mere humans. Because even skilled and experienced and superbly bright people can err. So that the appellate judges are not just necessarily smarter. It's just that they have to look at these errors. And what do they look at? Error of law, error of fact, error of mixed law and fact, discretion, inferences. They do all of those things. And in relation to the universal law application, well, you have stare decisis to help you, and you have the principle of precedent. Then he goes into the question of, with regard to lawmaking, should that be something done by the Court of Appeal, which is a middle court, or should it be only the CCJ, which is the apex court? Then he speaks about review or a hearing. Is it a review or is it a hearing? Those are important issues as to how you deal with your appellate work. And he says, in Barbados, the Court of Appeal is a review court. Then he comes to the attorney now, and he says, how can the attorney assist the court? Well, if you're trying to show that a decision of the court below is wrong, you don't need 22 grounds if it's only 3 grounds that are relevant. And if one is dispositive of the appeal, then you only need 1 ground. And then you must learn as an attorney to write written submissions that go to the 3 grounds, not to the 22. And the written submissions, you need to learn how to do that because the written submissions come first. That's what the judges see. Then after that come the oral delivery, or oral submissions. They must relate to the written submissions and relate to the grounds, and maybe only 3 or 1, not 22. So he says, what you have to focus on is that you're not wanting to win. You're wanting to help the Court of Appeal, and the CCJ Court. What I said is that it's important advice from a brilliant jurist, a must read. Then we go on to chapter 4. Whose say holds sway? And this is consent to medical treatment for children, Rose Cameron. Although retired now, she joined the faculty as a lecturer in 2015 and served as a deputy dean for undergraduate studies and student success between 2018 and 2021. You heard earlier, she was the first PhD in law to graduate from the Faculty of Law at Mona. That's the caliber of persons contributing to this wonderful text. So she calls on us to examine the competing rights when children fall ill and the important stakeholders in the decision-making process relative to the treatment. Will it be the child, the parents, the doctors, or the courts? She queries whose consent will prevail when there is a dispute. She puts forward the question, though, of why is there a need for consent? But of course, if there's going to be surgery, invasion, intrusion into a body, then it would be battery and trespass. So you need to have this consent. So she gives a good canvassing of what are the laws that are relevant, common law, statute, in relation to consent, in relation to medical treatment. And then, of course, she speaks to how now you have to have informed consent too. It's not just consent, but you have to have all the information that is necessary for you to do that. So she says, at what age can the child fully comprehend what is happening and agree to the surgical invasion of her body? When does the child lack the capacity to consent? Is it through age, illness, or immaturity? And is that when the parent becomes the person who must give the consent? So, in disputes between parents, what does the court do? The paramount importance is what is the best interest of the child. Disputes between doctors and parents, even when sometimes the parents can have these strong religious beliefs, still paramount importance is the welfare of the child. When doctors differ, still paramount importance is the welfare of the child. Sometimes the doctors are unable to obtain consent because the child doesn't have the capacity to do so. Then the doctrine of necessity steps in, and she makes it very clear what are those 3 planks. We all remember them. The act is needed to avoid inevitable and irreparable evil. No more should be done that is necessary for the purpose to be achieved, and the evil inflicted must not be disproportionate to the evil avoided. So that is only when you're going to say, well, you're going to the doctrine of necessity, it has those 3 planks, and you have to be showing that that is what you're going to rely on. She speaks to the Office of the Children's Advocate. It's important because that was established by the Children Care and Protection Act of 2004, and the Children's Advocate can now bring their cases when the parents are deciding to be difficult and have religious beliefs and don't want the children to have all sorts of treatment that is due to them. They don't want chemotherapy when really they need to get it. Then the Children's Advocate is there to protect the child. The court is only involved when things are brought to it. People don't want to think that the court is just romping around trying and see how they can interfere in the lives of children. No, but there is parents per trial, and there's wide worship proceedings. So it's important to recognize that the court is there to be that resort to protect children, and particularly with regard to the treatment that they need in circumstances when they may not be getting the protection of those who should protect them, like their parents. So she says that the court should adopt a participatory approach when dealing with children, pursue the paramount objective of operating in the best interest of the child, and approach the medical treatment of children with the focus of obtaining consent. And if you can't get the consent, well then the doctrine of necessity is where one would apply. Then we go. It's a powerful, informative discussion, and children will always be a compelling subject. Moving on now to our wonderful Susan Folks-Coulson in the corporate governance chapter. Susan Folks-Coulson of Blessed Mary, author of this chapter, BA Econ, LLB on BLC, Senior Lecturer and former Deputy Dean of the Faculty of Law at Mona. She was the course director in Common Law, Corporate Management, and the postgraduate course in Corporate Governance. She received several awards, presented extensively, and authored comprehensive texts on this area of the law in which she had a keen abiding interest. Her focus was on fiduciary duties in relation to the directors and companies. And her approach, she starts out by saying that, that the directors' focus was always to be the company. But it has grown now to have moving from a shareholder primacy model to a stakeholder model. So the directors and officers need to consider the interests of the company and the shareholders, as well as a wide range of shareholders' interests. That's a question of discussion, because her position is that the focus of directors is the protection of the interests of the company. But she tells us now about what are the two main obligations of their they have two main obligations: their fiduciary duty and the duty of care and diligence, and that is also to be encompassed by them acting in an honest belief. What is the fiduciary duty? Not to have a conflict of interest, not to make a secret profit, and to act bona fide in the interest of the company. And then she speaks about how important it is to act in that honesty and good faith. She speaks about the types of directors: de facto, de jure, shadow. They all have to have this fiduciary duty applies to all of them. She speaks about when you have all of those fiduciary duties and the honest belief and the honest behavior, you also must remember that proper purpose test. The proper purpose test now is where the director has to show that they are obliging with all of those that they should oblige by. Then she goes to this interest that not only is the interest of the directors to be focused on the company, there are some people that say, there are some instruments and some lawyers is developing that it should be for employees, it should be for suppliers, creditors, consumers, and so on. But what folks goes and says is, where there are competing interests, the duty to act in the best interest of the company trumps other considerations. Well, she then goes into the whole issue of the vicinity of solvency. That is a very concerning thing for people. So the English people have something they call nearing solvency, the risk of insolvency, doubtful solvency, and financial predicament. So you have a situation now where should you embrace creditors, or is your duty still to the company? Well, what our professor says here is that the interest of the corporation is not to be confused with the interest of the creditor. And so the director's fiduciary duty does not change when a corporation is in a nebulous vicinity of insolvency. You just act in honesty and good faith. You can do that. There's a large chance you will save the company. If you save the company, the creditors will be happy too. So, what you need to try to do is to avoid this conflict of interest and appreciate that if you do as you're supposed to do, follow your fiduciary duty, and you have to worry about the liability. Because there is liability for breach of fiduciary duty. You have to account for secret profits, joint and several liability for loss, voidability of contracts if there's a breach of the conflict of interest, and you can have disqualification also if you're as being unfit to serve, and you can be sued under the derivative actions and oppressive remedy. This piece, Governance by Susan Fox Goldman, is just great, illuminating, brilliant. I was wondering if I would take up the whole hour on it, and I'm very sorry that I had to sort of make sure that you understand how important this is. The next chapter is on the defamation law as the enforcement of morals, the case for the greater use of the moralist approach. It's by Gabrielle Elliott Williams, LLB Honors, LLB Cantab. She's a lecturer in the Faculty of Law at Mona, where she teaches international law and human rights law. She has numerous publications on various topics. But the first thing she speaks about is defamatory. What is that? Defamatory conduct is that which tends to lower a person in the estimation of right-thinking members of society generally, exposes them to hatred, contempt, or ridicule, cause other persons to shun or avoid them, discredits them in their trade, profession, or calling, or damages their credit. This definition, she says, illustrates the law of definitions objective to afford redress, in some instances for actual or presumed but unjustified injury to reputation in the sense of a claimant standing in the community. And basically, she's saying that you really are looking at what right-thinking members of the society are saying, and that's what the judge's eyes are looking at. But the question is, she says there are two really distinct approaches to determine the loss of standing in the community: the realist approach and the morality approach. And she's recommending the morality approach. So, give you an example. She has several, but give you an example. For instance, would you think that if there was a person who was reported to the police for unlawful conduct taking place in the club, and therefore the claimant was saying that the person is a police informer, would you think that's defamatory? Well, if you take the moralist approach, it couldn't be defamatory, because if you're bad behaving and somebody sees a police coming by, you want to tell the police this is what this person is doing, that's a good thing to do. But if you are somebody now in the general people of the general members of the public who feel a police informer is a horrible thing, you're supposed to protect the person who is doing these bad things and you're not to tell anybody anything, then that would be the realist approach. Supposedly the largest part of the populace is saying that that's defamatory. And so she's saying, don't use that approach. You need to use a moralist approach, and she has indicated that if you don't, you can end up not aligning with constitutional values of dignity, equality, and non-discrimination. In fact, what you might end up with is, I think she describes it as values that are morally repugnant. So for instance, in the early days, if somebody said that a white person was black, defamatory. If they said your blood was tainted with black blood, defamatory. If somebody said black and white were equal, defamatory. And those were the right things, allegedly right-thinking persons were thinking. So if those were able to succeed, you would definitely be saying that would result in a decision that was endorsing values that were morally repugnant. And then she moves on to gay labeling as defamation in the Anglophone Caribbean. And in this situation, she says, for instance, if somebody sues on the imputation of being gay, homosexual, or having an unacceptable sexuality, the real issue there is not that the success is to show that it's an imputation of a crime, given that we still have mongrel laws, but that the claimant's reputation to be restored, one must avow heterosexuality, aver that same-sex intercourse is immoral and sinful, liable to cause one harm, and to consider that acts engaged in by gays are so unnatural, and any unwanted advances from a homosexual without more, whose life would be considered so insignificant, could justify homicide. So decisions of the court, therefore, would continue to hold on to those prejudices and lend legitimacy to demeaning the exclusion of gays from the community. It's really a very powerful argument. So she's saying the reason why you have to use a moralist report. First, it allows the court to better align the common law of defamation with constitutional values of dignity, equality, and non-discrimination. And second, it can be used as a tool of social change. Sound. All right, here's one to wake you up. Chapter 7. Puss and dog don't have the same luck. How does that sound? An intersectional approach to fairness in sport. This is Dr. Jason Haynes. Now, he's an LLB honors, UWI LLM, PhD, LEC, MICR, CEDR, attorney at law, an associate professor of law and deputy head of research at the University of Birmingham School of Law. He was a senior lecturer at the deputy dean, graduate studies at the Faculty of Law, Cave Hill, where he taught sports law, international investments law, and administrative law, entertainment law, and intellectual property law. He has several interests in various areas of the law, has co-authored a text on Commonwealth Caribbean sports law, and has written several scholarly articles on topics in the law that he has an interest in. So his topic starts out in fairness. It's a concept of justice, equity, impartiality, integrity, legitimacy, propriety, and rationality. And he says you can't speak about sport without speaking about fairness. It's indispensable. And he says the legitimacy of sporting rules and institutions and procedures, fairness is an underpinning part of it. If you have fairness, it relates to not only the outcomes, but the procedures, the interpersonal treatment, and the decision justification. And without it, what will happen? There will be no legitimate sport because doping would be widespread, manipulation of competitions would be rampant, and women and other marginalized groups would be pushed to the sidelines. And he says, he gives you all of these important legislation and rules and regulations. And he says, what has really happened though, even though fairness is supposed to be there, it operates as a malleable concept that affords luck to puss, the Caucasian athletes, and no such luck to dog, which is athletes of color. And he says that his chapter is really to show how this has been impacted. And he starts out by saying that he knows that many people, including the great Professor Tracy, have written on the way that persons of color have been marginalized and discriminated against and so on. But he's focusing on in the sport. And he says there are so many interesting examples of it, because he started out by talking about these Norwegian handball players who wanted to wear shorts instead of bikini. And what happened to them? They were just fined. But when it came to the swim cap that the black swimmers wanted to wear because they wanted to put their dreadlocks and weaves and extension beads under it, they just completely banned it and said, even though it had no scientific evidence that it was affording any competitive advantage, so he said disproportionate, irrational, and unfair. Now there are these no disrepute clauses, a very powerful clause, I'm going to read it for you. No kind of discrimination or political, religious, or racial propaganda is permitted in any Olympic sites, venues, or other areas. It's a serious rule warranting disqualification or withdrawal of accreditation. Important. But when my little fellow goes and says, no war in Ukraine, no sanction. But when those black athletes protesting racial injustice and race relations in the US, you remember Thomas Smith and his, 68 and 72. And then decades later, black athlete kneeling on the ground against police brutality, what happens to them? Banned from the Olympics, banned from NFL, and their careers destroyed. Clearly, puss and dog don't have the same love. That is Dr. Haynes. Then he went on to speak about DSD, women of color. That means differences of sex development. It's a condition in which a person's chromosomes may not match their reproductive organs or genitalia. So everybody knows about Caster Semenya. And what did they decide to do with her? They said that because her testosterone level was too high, then she must use contraceptives to get it down. And if she don't, she can't raise. So it, as he says, oppressive. And this is important. He said oppressive and crude and paternalistic, targeting women with DSC, which of course is more women in color. But here's an important question, which is why you must buy this book. This chapter is really powerful. Listen to it. How can a female transgender woman be permitted to compete against women? Yet Semenya and others who were not born male have always identified as women be excluded from participating with females when a person born male who was transformed into female is allowed to. Clearly Semenya and fellow DSD athletes of color, dog, do not have the same look as their white counterparts, puss. Then he also talks about the anti-doping regulations and so on, where the Caucasians somehow, and they manage to be able to get their matters heard quickly. And it's dealt with, and they get very small fines. And yet their counterparts, it takes a long time for it to be decided. And then they get these harsh sanctions. And the women even worse than the men. Okay. Moving right along now, but all I have to say about that is that being a sports enthusiast myself, it was fascinating and compelling. So we move on now to tort liability in the hospitality sector. I don't know if I really need to say anything about Professor Cornellini, but he's MA Oxford, LLMN, CIPE, CIME, all these things that I don't even know what they are. But anyway, he's a barrister, and he's emeritus professor of law at UWI, where he taught for 30 years. He was general editor of the Caribbean Law Review for 16 years. He researches several areas of the law. He has authored or co-authored 5 Commonwealth Caribbean Law series, I think we all know them, and has published several scholarly articles in leading international journals, and is cited in superior courts, major textbooks, and legal periodicals globally. Now, in his essay, he starts out by talking about how COVID had impacted the hospitality industry. But after that, he says, let us just think about, now that everything has come back, we're in with personal injury. And once there's personal injury, the issue arises, the choice of jurisdiction. Where is this matter to be tried? And he says, well, with that choice, the injury, the person with the injury, they're going to want to go to their home country. Why? Because they're going to see that it's more convenient, costs, contingency, fees, jury trials. The hotel is going to say, no, I want it to be here. Why? Because it's going to take up a shorter time, the damage is going to be less. So that's an issue. That has to be decided. Then you have foreign non-convenience. Once they want to file it in the foreign court, you're going to have an application definitely to strike that out. And that is going to be based on whether there's an alternative forum, which would be maybe in Jamaica or one of the Caribbean countries, and you're going to say it's more convenient, cause less disruption. It will not cause undue prejudice. It's in the public interest, the whole consideration of the case. There's a private interest factor. Now, obtaining evidence, witnesses' ability to view the site, and often in these clauses in relation to visit and so on, you would have clauses that say it's going to be heard here, and the law is going to be this law that is going to affect it. Then there's the liability and assessment. I found this very interesting because, the law that's going to adjudicate is the law where it is, but yet the assessment and damages, of course, is not the law where it is the foreign law, but where it is here. But that can be carved out also in relation to substantive law, heads of damages and so on. Lots of discussion that you have to read about. Then occupiers' liability, different in different countries, slip and fall. That is just something that one has to get accustomed to. Different standards for bath, shower. How the visitors always come here and they fall down in the bath, and they fall down in the shower, and they fall down the steps, and they fall down the path, and they fall in the grass. So this is something that one has to know. Then there's the eggshell skull, where the obese person sits down on a small stool, but when they fall down, they get heart attack or brain injury. So you have to understand what is the responsibility, what is the liability. Do you have to do the first aid and stop? Wait for the people to come. It's all about negligence and the duty of care. Then they're going to have exclusion clauses. Those exclusion clauses say all cars park at the owner's risk, and as you go out there, your car gone. And don't bring any property on there. Don't put anything in the vault, because that is going to go. But there's these clauses, but the clauses have to be contemporaneous. You have to read all of these wonderful things so that you can know exactly how to protect the client. And then there's the package holidays. When the tour operators like to say, come, because it's a wonderful thing, everything is great. And they give you such a wonderful, you think, why aren't you there from yesterday? But then when you reach there, nobody checked out that the lagoon have a very deep part and a very short part. And of course, you think you're going to the shorter part, there's a deep part, you're going to nearly drown. And then they're saying they're completely excluded. So you have to be careful to read all of these things. And then there's the building code standards. You have to make sure that those are correct. And you have to also ensure that. So what it is that there are just so many things in the tourist industry. And when Professor Codellini started to list them out, that's when it's very, very interesting. Then comes the harm to reputation. It's a serious thing. I should say that with the Codellini piece is very informative, very learned, and it's delivered by one of the Caribbean's most erudite professors, in my view. So now we go on to the harm to reputation. It's a serious thing. This is by Dr. Colin B. Lewis, BA Honors, PG Dip in Law, LLM, is a lecturer in employment law at UWI, Mona. Her research is focused on law, technology, and the internet, with special interest on cybercrime and commerce, privacy concerns, and data protection. She has also ably managed over the years to merge her research interests of media and technology. She spoke about the Defamation Act and was very concerned that in 2013, when we were amending our act, she said it was a time when we should have looked to ensure that what had been done in Australia and the UK, we did. It was an opportunity, and we just missed it. And that opportunity was to try to create a balance between the person who is claiming the defamation and also the right of freedom of speech. Because what we have here is a presumption of harm. So when you have this presumption of harm, really all the person who is making the claim has to do is to show that there's a defamatory expression that was published, it was concerning the claimant, and the defamatory statement was published to a third person. There's no obligation to show that there was serious harm to you. So what you have is a preponderance of trivial claims, and the defendant having to show that there was no serious harm. And that is putting a lot of burden on the defendant. So therefore, what it is that, I think it is Dr. Lewis is recommending, follow what the English and the Australians have done. The Australians first started out with something they call a triviality defense, but that didn't work too long because it still put a burden on the defense to show that there had been serious harm. But what the English did, if you can't, as a claimant, show serious harm, then it's not actionable. Because you cannot just have it is true, you're not supposed to go around the place and just say that people have been defamed, and they're just saying all kind of things that are defamatory. But you have to show that there has been serious harm before it's actionable. Then we go on to the forgotten exceptions of the revised Treaty of Chaguaramas. This is chapter 10. Now, this is Andre Shackelford, BSc, LLB Honours, a lecturer at the Mona. He teaches the undergraduate courses Real Property 1 and 2, Introduction to International Investment Law. His research interests include international economic law, the relationship between law and information and property law. He has appeared before several courts in the higher judiciary and in apex courts. He has authored an interesting essay on biometric information systems. Now, what Mr. Shackelford was interested in, he was focusing on the obligations of member states under the revised Treaty of Chaguaramas. So he commenced with a bold and very accurate statement that rules are at the center of legal systems. In any system of complex rules, there are exceptions. He lists the 15 member states that make up the Caribbean community, and he notes that the CARICOM was established by the RGT, and he says it covers a wide range of things: industry, agriculture, trade, transportation, and competition. He calls them the concretized norms, the ones that deal with free movement of goods, services, capital, and labor, and those establishing competition framework. But his concern is that if you have a complex legal system, then there are going to be several rules and exceptions to those rules. And his concern is that what has happened here is that we have all of these rules and we have the exceptions. The exceptions are set out in section 2261 of the RTC, but persons who are going to the court are not using these exceptions. And the exceptions are really a defense when you're charged have breached an obligation under the treaty. But if you don't go to court with the exception, then the court is not able to look to see whether the exception is applicable when you're saying that the treaty has been breached. And so his concern is that these rules now have become what you can call immutable constructs. And so he's concerned that you're getting decisions out of the court that are not as they ought to be. It's a really very interesting international discourse. Recommended reading. So here we get to Professor Vassiani. It's called Shipwrighter Reconsidered. Professor Stephen Vassiani, BSc, WW, BA Oxford LLM. He's a lecturer at the Mona where he teaches public international law and international mooting. He has worked extensively in his area of research interest: international law, law of the sea, human rights law, and investment law. He has had various positions in academia and public life. He received national honors, the Order of Distinction Commander Class, for service in the fields of law, education, and international relations. He has served on several international bodies and has authored many scholarly articles. Now, I have to read the beginning of Professor essay. After that, I'll just wrap up. He starts by putting his focus immediately in concept. This is what he says. 25 years ago, following months of public and private argumentation, Jamaica and the United States completed a bilateral maritime treaty designed to tackle the well-known and intractable problem of unlawful drug shipments in the Caribbean Sea. The treaty, he says, set out rules for American naval officers to search both Jamaican vessels at sea and foreign vessels in Jamaican waters. It also gave Jamaica the right to undertake searches of U.S. vessels and foreign vessels in U.S. waters. Professor Vassiani tells us that this treaty became popularly described as a shipwright agreement. Aside from other things, what was germane is that Jamaican nationals could join U.S. naval officers on U.S. ships as shipwriters. And while aboard, they could authorize U.S. officers to undertake searches of foreign vessels in Jamaican waters. Equally, U.S. nationals acting as shipwriters on Jamaican ships could authorize searches of vessels in U.S. waters. There are several other aspects of the agreement, but the impact in relation to this essay was on maritime drug trafficking. So what Professor Vassiani did was to share with us the difficulty of even to arrive at this treaty. He said it took some time, marred in controversy, suspicion of hegemony of the United States over the Caribbean territories, because they didn't really want to treat with us as individuals and having our own sovereignty and things like that. We wanted to lump us all together and we wanted to be separate. But he says after some time we arrived at a compromise and we came up with this. And he says what we did is that we arrived at a situation where they had to seek authorization of a senior Jamaican official before a search could be undertaken. And so that was really a major step. So now I say that Professor Bassiani takes us through the most fascinating journey, starting with the Maritime Areas Act, which defines Jamaica's maritime zones. So we start out as an archipelagic state. So we have internal waters, archipelagic waters, territorial sea, contiguous zone, exclusive economic zone. Sound funny? Very interesting. And when you go out, then he says, this was interesting. After you get out of the exclusive economic zone, you're on the high seas, and we have very limited jurisdiction there. So I thought I should make a note of that so that anybody who is interested in doing anything on the lower of the sea, out of there, we don't have much limited jurisdiction. But we are a part of the Law of the Sea Convention. Jamaica are a part of it, and also subject to customary international law. But then he tells us, did you know that if a ship is in port, that is like if you're on land. So the authorities have the same authority over the ship in port as they have on land. So you can't claim that you're in any waters because you're right there to be subject to Jamaican authorities. There's a case, David Chin, the Attorney General of Jamaica. It's well reasoned, it's very interesting. Professor doesn't agree with everything that Justice Batts arrived at, but the point is that it's between the professor and Justice Batts, you get the law fully. And it's all about Lady Lawler. So like a good name to give a vessel. But anyway, Professor now, he tells us about the archipelagic waters. And he speaks about what is the innocent passage, what authorities you're subject to, who can search you when and where and where. But he tells us about our territorial waters that are 12 miles out, then the contiguous zone that is 12 nautical miles out of the territorial sea, and then the exclusive zone which is 12 more nautical miles over there. That's it. I thought it was fascinating. So there are lots of rules and conventions and legislation and everything for you to read in Professor's essay. It's really just beyond fascinating. But I just want you to understand, which I'm very concerned that he had, which is what he called the waiver of jurisdiction. There was some amendments to the Maritime Drug Trafficking Suppression Act in 2016, where the minister can exercise a discretion to allow a Jamaican citizen beyond our territorial sea to be handed over to the U.S. for prosecution and trial in U.S. courts. Now, bear in mind the very human rights breaches that have taken place in relation to persons who have been handed over. It really is an interesting question requiring continuous debate. Ought a minister to have such a discretion? It's a journey from port and internal waters to the high seas, focus on drug trafficking, guided by the brilliant and very knowledgeable Professor Bastian. You can't get any better than that. Finally, chapter 12. So, this is the exciting text entitled The Juridification of Good Governance in CARICOM Law. Dr. Nita White, BSc UE, LLB, LLM, JSD, a lecturer in the Faculty of Law at Mona. He teaches law of international organizations, law of international courts and tribunals, and Caribbean international law. His research focuses on public international law, international investment law, and regional economic integration. Dr. Wade previously served on the appeals chamber of the International Criminal Court. He has written several articles on international criminal law. Why I have done this in relation to every chapter is for you to understand the depth of knowledge of the persons who have contributed to this fantastic text. I don't think there is pure doctor and professor and people who have done years of study and are so knowledgeable in the area. That's why when you finish, you think you can talk about it. And if you're even not so sure, just go back to the text and try to catch it back to make sure that you're not misreading or misstating what they have said. In relation to this, though, he's speaking about the CCJ now and the treaty, and he's speaking about good governance in relation to the membership states and the whole CARICOM region. And he starts out by saying, well, what is good governance? And he goes into good governance. He gives us ideas of what it is. He says respect for the rule of law, duty of transparency and efficiency, including the duty to give reasons, duty to give reasonable and adequate notice, and the duty to provide an independent and effective review system. So he says once the CCJ complies with those core components of good governance, what do you get? He says if all of them are complied with, the decisions of the CCJ in its original jurisdiction paints a portrait of the standard of governance sanctioned by the terms and ethos of the revised Treaty of Chaguaramas. Additionally, once in compliance with its core elements, as previously described, the community is a standard of governance, would be the minimum standard of governance for CARICOM member states. The decisions of the court in its original jurisdiction bind all CARICOM member states. Community law, which includes the CC decisions, prevails over inconsistent domestic law. So the standard of governance that the court sets out in its controlling law for the community will ultimately have the effect of raising the quality of governance across the region. The full details of this essay are interesting and compelling, and really must read. So in conclusion, I say 12 extraordinary chapters from 12 eminent jurists on 12 fascinating legal concepts. And I have said repeatedly, they're all a must read. You will enjoy, you will be informed. Thank you for your attention. Thank you.
Thank you very much, Justice Phillips. Oh, please don't go. May I invite you to come back, please? As I was speaking too slowly. Dr. Celia Brown Blake will make a presentation.
Justice Phillips, on behalf of Mona Law, I thank you for the very, very comprehensive review that you have done of the book. So I ask you to accept this as a token of our appreciation for the support that you are always giving to the faculty. And I suspect, if not, I hope, that it will help you to relax after all that intellectual energy that you have expended on your critique. Thank you. Sure.
Sure. You want me to hold? Will it, I don't want to. Will it break? Like to drop
I don't want you to lose it. Thank you.
Thank you. Thank you very much.
Colleagues, so you remember our first word, eudaimonia. You remember that one? Yes. Justice Phillips gave us some others. Words that lawyers don't use all the time, or not all lawyers use all the time. Justice Phillips, you gave us sociolinguistic. Yes? And archipelagic. Yes? And what this is showing to me, I don't know for you, is that this work is covering quite a bit. It's taking us into different areas that we ordinarily would not go in. And as she said a few times, go get the book. I endorse that wholeheartedly. Now, colleagues, please permit me. No. I don't have any grave error anymore. But this time, I noticed that a few colleagues, a few distinguished colleagues and guests joined us after our welcome. And not just the welcome, joined us after the welcome and my addenda. So at this point, I'd like to acknowledge and welcome former Court of Appeal President, the Honorable Mr. Justice Seymour Panton. Director of Public Prosecutions, Paula Llewellyn. Professor Trevor Monroe. I mentioned that we were expecting guests from our law schools. I understand they are here. And so the principal of the Norman Manley Law School, Miss Eulalie Greenaway, and the principal of the Eugene Dupuche Law School, Tonya Baston Galanis. Thank you so much for being here with us. All right, so we'll take a much needed break. A much needed break from words, all these words. And so right now, Joel Taylor will help us to take that mental break with a musical presentation. Thank you very much, Joel. And as the program indicates, Joel is a Mona Law alumnus who still finds time to come and share with us. Thank you very much, Joel. So we're getting right back into the words. Let's go. And as Justice Phillips indicated, Dr. Celia, Justice, yeah, man. Justice Phillips indicated that Dr. Celia Brown Blake raises the concept and issues around sociolinguistics. And this was another pause for me in this text. Now, Justice Phillips read something I was planning to read, but just to remind you, it is not very long, just to remind you what Dr. Celia Brown Blake said. She says on page 46, the failure to adopt, particularly via constitutional instruments, a non-colonial language as a national language that would signal a break from the colonial order was consistent with the intention on the part of Caribbean independence leaders to continue to govern in the same way as had the British. But, so she tells us what happened, what was, how did we get here? But the thing that really got me was what she said at page 58. Dr. Brown Blake says, and she's speaking to a discussion that is going on in Jamaica right now. I don't think that was her intention at the time, but certainly I think it's very relevant. She says here on page 56, it is submitted that in the context of the sociolinguistic evolution that has occurred in the Commonwealth Caribbean post-independence, leaders of the renewed Republican movement have a duty to redress the disadvantage and unfairness to which vernacular dominant speakers have been exposed, and to make them substantive citizens. She proceeds, the architects of the modern Republican Constitution would do a great injustice if they proceeded with eyes wide shut to the language issue. I think this is very relevant to the conversation we are having right now about moving to this Republican stuff. So thank you very much, Dr. Brown Blake, for giving us a new tool in our analysis of how we should move and in what direction we can go to be better. All right, so our program says, as my dean was pointing out to me, at least I stick to the program. I will now invite Dr. Colleen Lewis, who will lead us through a presentation that speaks the contributions from the contributors. Reflections from the contributors.
Thank you, Lucy. Okay, so as you can see, we have 12 contributors to this piece. And I think the dean was a little nervous to give all 12 of us an opportunity to speak. So we got a message that we should share only three words about our reflection, our thoughts on this process. And I know that certainly it was an honor to be a part of this work. So we got the mandate during the COVID years, and we all recall what that was like, working remotely and not seeing many persons face to face. But that did not deter our able dean from challenging us and motivating us to get this work done. And I know that at the end of it, of course, we are truly honored to have participated in recognizing 50 years of study of law at UWI. All right. There we go. So, Dr. Yantu Williams, research assistant, asked the contributors this. Can you please tell me 3 adjectives that describe your experience when writing your chapter? Okay, so that's me. And I said it was enlightening and certainly invigorating and deep. Just having a look at the different perspectives of other jurisdictions to address a challenge that we have within our own jurisdiction. Dr. Jason Haynes, he said it was thought-provoking, engaging, and inspiring. Gabrielle says she was dejected, angst, and patience would describe her experience. And Dr. Neto said pride, competence, and contribution. Professor Kudalini, he says it was enjoyable, relaxing, and redemptive. And Dr. Celia Blake said, a mind-expanding, interdisciplinary experience. I'm glad that I'm not booking up on any of those words that our professor and dean used so far. Patrick? Okay. Okay. Dr. Rose Cameron said it was thought-provoking, unsettling, yet intriguing. And Andre said it was insightful, demanding, and rewarding. Ms. White says it was amazing, exhilarating, remembering. And Justice Andrew Burgess said it was challenging, exciting, but satisfying. Or Dean, oh gosh, thank you, Dean, for not using that word. Or Dean says it was explorative, enlightening, and exhausting. Honest. And Professor Vassiani says it was technical, structured, and consequential. And so we have this graph of the various different experiences that we had. And I think despite some of those words which may not seem as positive, I think at the end of it we would have said overall it was rewarding. And we thank the Dean and editors for the opportunity to be a part of this process.
Yes, thank you very much, Dr. Lewis. And we are indeed grateful for the work, the sacrifice, the commitment, the diligence that each of our contributors put into producing such an amazing text. So please give them one more round of applause. Now on your program, you will see a note from UE Press. When you have time, please have a look. And please look at that note there. But right now, I will invite Professor Ali to make a few presentations on behalf of the UE Press. There are 3 presentations to be made, and these presentations will be to the following persons, well, institutions. The Jamaica Library Service. Now I understand Ms. Dion Barnett, Senior Librarian, is here to receive this token, receive this book. The UE Mona Library. Mrs. Nicole Lewis Prawl or Mr. Adrian Duncan. And the National Library of Jamaica will receive the book soon. Thank you, Professor Ali. All right, ladies and gentlemen, it's been quite an afternoon into evening. Thank you so much for your company. Thank you also for your support of the faculty in different ways. And at this point, I'd like to thank on behalf of the editors and organizers of the event, all the team members who worked tirelessly to make this publication possible and this wonderful event possible. Thank you very much. Now, I have two final things to say. One is, copies of the book are available outside. And I'm sure you are just eager to get your copy oh, you already have your copy, sir. Thank you very much. Thank you very much. Feel free to grab a copy or two and share this distinguished piece of work. And my second announcement, which is my final announcement, is, it's an invitation to refreshments on the rooftop. So feel free to take the stairs all the way up or to take the elevator and go to the 4th floor. And that's it from me. Thank you very much again. Enjoy the rest of your evening.